Now back to the show. This is AM 650's The Law Show.
Sterling Fox with you this fine first Sunday of 2014 on The Law Show with our guests from Lindsay Kenney LLP, Angela Thiel, and Christine Eilers, our lawyers in the Vancouver firm lklaw.ca. And we're talking family law. Both our guests are family lawyers. And the new Family Law Act, which we've had for less than a year in British Columbia. So given that we've now got 10 months under our belt, Angela, what's changed, if anything? You talked about some of the reasons the law was brought in because we were deficient in a couple of areas. This seems to have addressed that, but in court and in the process of doing family law now in BC, what's changed?
Well, the first thing, of course, and the most important thing is that common law spouses are now treated as married couples used to be with respect to property division.
Now, did we not have that at BC?
No, and a lot of that is just one of those...
It was complicated to try and get an interest in property as a
really?
common law spouse.
I guess we're too close to California, and we just assume that all of that is the same everywhere.
Yeah, it's more a a common law wife or husband could come along and say, I contributed money and I contributed labor to property.
Right.
And therefore I'm asserting an interest, but they had to prove an interest. Now they have it automatically by statute.
Okay.
And so now the only dispute is, the major dispute now is, what did you have coming in? Or what did you get by inheritance or gift from family members during the course of the marriage? And what will happen as a result of those types of now we're going to count from day one, and we're going to look at the increase in value.
I just wanted to ask you briefly, what is the term, length of cohabitation term until you are suddenly a common law person, Christine? Is it 6 months? Is it 2 years in order to qualify as a common law spouse?
For the purpose of this act, it's 2 years.
2 years,
Yeah.
okay. I didn't know that.
Yeah.
But the complicating part is you start counting the asset increase from the day you move in together.
Okay.
So what we're seeing a lot of people, we expected this, but it's surprising how quickly it's caught on. People coming in saying, we're moving in together.
Right.
Let's look at what I have now. And what does the statute do? And I want an agreement that says, I don't want the statute to apply to me, or I don't want it to apply to this asset. And that's a sort of a growth industry for lawyers, but it's also incredibly important. Mm-hmm. And
so this is basically, and I'm using civilian terminology here, but this sounds to me a whole lot like a common law prenup. Is that close?
Yeah, absolutely. A
The
cohabitation.
decidedly unromantic prenup. Here we go again with this stuff. And Angela, you keep telling me, I don't care how romantic you don't think it is, Sterling. It's incredibly important.
If you don't do it at the front end, I mean, think about this, Sterling. Can you tell me 6 months ago what was in your RRSPs?
Maybe within give or take. Yeah, probably.
Okay, can you tell me 2 years ago?
No.
Right. So you probably got a document that tells you what was your RRSPs 2 years ago.
Well, it's just year end, so I've cheated. I got one recently.
All right.
But aside, 2 years ago, I couldn't begin to tell you.
But there's probably a document there.
Oh, sure.
But 2 years ago, what was your house worth?
Mm-hmm.
So our market's gone up.
Yep.
It's gone down.
Yep.
Maybe you paid down a mortgage. You took a lump sum and paid it towards your mortgage.
Right.
So when you document it as of day one,
so going back 2 years now,
Going
right?
back 2 years now.
Okay.
So what I'm seeing is people that have just moved in together. I just did one the other day where they'd moved in together December 1st, and I signed up that agreement on December 23rd, and wherever it was. But it was really important for that fellow to say, here's what I have now, here's what I'm prepared to share if we stay living together. Because if we, because I would have had to share everything, but I'm only prepared to share certain things. Mm-hmm. Because otherwise, he's not going to really be able to keep track 2 years from now.
Right, and that's okay in BC to declare what it is you bring to the relationship and how unwilling you are to share with it. Should the relationship go away, well, then you get to keep what you came in with, having declared it up front in the first place.
Yeah, you can contract. Your agreement can either say, this is what I had, and the law will apply to me, or this is what I have, and I'm going to contract out of parts of the law with respect to some of my assets. Or another way of doing it is, I'm not going to tell you necessarily what I have now, because it's really complicated. We can't really value it. But I'll tell you, for every year of our relationship, I'll give you $50,000 or $100,000, so we don't have to fight about what was it worth then and what's it worth now.
Okay. I have yet to meet that mysterious person.
Yeah, and I think, Christine, we've had probably as many different versions of what people would like to do.
Yeah.
I'm sorry, Christine, please
Well, I
go
was just
ahead.
going to say, one of the interesting things with the new act is that it is placing more emphasis on upholding agreements. So again, taking a bit of discretion away from the judge and saying more of the time these agreements will be upheld as long as they're fairly negotiated,
Right.
and there's proper disclosure and all that sort of stuff. So it gives us a bit of freedom to do more in an agreement and not worry about a judge at the end of the day saying, well, I don't really like this and I'm going to shift it around and do something that I think is fair.
So we have two cases now on agreements. One of them, Christine and I were counsel on, and that was an agreement that the court decided ultimately was neither fairly negotiated procedurally, nor was it fair substantively.
Was this agreement between common law people or married people?
It was between common law people.
Okay, which in the law is basically the same thing now.
Now,
That's
yeah.
correct.
Right,
Yeah.
okay.
And then the second case I just recently read, the marriage agreement, and I think it was under the Family Law Act. The marriage agreement had been written relatively well, but a circumstance had arisen which hadn't been contemplated by the statute.
Right.
So the judge went through the judge went through the agreement and said, I can't get around the way this agreement was contemplated, but I'm going to apply fairness principles, and I'm going to say that you didn't contemplate this. It would be unfair to do this in the fashion this agreement would otherwise operate. So by way of fairness, I'm going to do it this way. Now that was, I think, still under the Family Relations Act. Under the new act, it would have to be significantly unfair.
Yeah.
Oh, I see.
So again, less discretion for a judge.
In this particular case, I think it would have been the same answer under the Family Law Act, simply because they had set out a certain intention, but they hadn't written in this particular circumstance arising and what
Right.
they would do with it.
Unforeseen circumstances.
Exactly.
Yeah. In British Columbia, a prenup, a marriage prenup is referred to in law as a marriage agreement, correct?
I think the act just refers to it as an agreement.
An agreement? And so is there a different legal term for a common law prenup?
No.
Or it's just referred to as an agreement?
That's correct.
Okay, just checking my terminology.
Well, no,
this is new law, people, and I'm not a lawyer.
We
It's
use
tough to
the
keep up
terms
with all this.
interchangeably, sort of. We
Okay.
call it a cohabitation agreement, a marriage agreement, a prenup.
And often you're doing they're starting with cohabitation, but you want the agreement to continue to apply after marriage. So you'll call it cohabitation / marriage agreement.
Oh, okay, okay. And what percentage of young people coming into relationships, either in the married or cohabitation, what percentage of those people are creating these agreements amongst themselves?
It's hard to know a percentage, but certainly I've had quite a lot come in. Before, under the old law, it was actually to your disadvantage to get an agreement if you were going to be living with somebody in a common law relationship, because it actually made it easier indirectly for the non-owning spouse to get an interest in your property. So now it's in the owning spouse's best interest to get an agreement to say what they had, and if they want to exclude that asset, to specifically say that that asset is excluded. And people seem to have heard about this. It's been in the news. It's, there's been a lot of articles about it, and people are talking about it.
Maybe they're listening to our radio show.
Maybe they're listening to our show. Maybe
One
their
can
mom
only
told
hope,
them.
Angela, yes.
And so people have heard about it, and I've had quite a lot of younger people that are moving in together, and they don't know where the relationship's going to go, but they're
Right.
getting a cohabitation agreement to be on the safe side.
Interesting. And typically, for a young couple, just kind of, well, what the heck, let's go
Yeah.
for it. What would that cost, Christine, to come down and see you and have something hammered out that both sides can easily agree to? What typically would that
It
cost?
definitely depends on the nature of the assets and how much work needs to be done.
Right.
But my experience
Young
with most
people,
lawyers,
let's just, young people typically don't have a lot of assets.
Yeah.
They're just sort of on the go and trying to build assets.
See, it's interesting because if you really don't have anything and you're moving in together, then you don't really need an agreement.
Okay.
Because normally the law as it stands would apply and that would make sense. It's usually when you either have a bunch going into the relationship and the other person doesn't, or if you're expecting a big inheritance or you're a beneficiary of a trust, something like that, that's when you want to get your assets protected and get an agreement. And so those situations are different, but I think most lawyers have been saying it's kind of anywhere from $1,500 to $3,000 approximately for
and that's for both parties, that all people are happy, sign, and away you go.
No, that's, I mean,
No?
I'm basically saying to people, you're going to expect for me to start looking at it and drafting it.
Yeah.
And I'm a more, higher hourly rate than Christine. So I'm basically saying, think $2,500 for me to draft it. But if they come in and they say, oh, well, and sometimes there's this upfront discussion, and I'm saying, well, generally I ask for a $2,500 retainer.
Right.
Then they come in and they say, I've got 7 companies, I've got 3 properties.
This is going to be complicated.
And it's not complicated, but I need to specifically draft clauses for each of those situations,
right.
all of which, there's not a template. You've got to draft, okay, this particular cottage that belongs to your family, that you have a 1/5 interest in, but you and your spouse are going to use together. I need to define it, say what it's worth, say what you want to do vis-a-vis your spouse. So there's a paragraph just for you that's got to be drafted by me. And I can't just go, oh, let's just fill in a blank. And then each specific asset, you may want to do different things. And I may want to tell you why what you want to do probably isn't the best thing to do. So I'm using, I'm not just drafting from a oh well, why don't you just do this? It's, I think you'd be better to do this because there would be less likely a judge would find it unfair, and it's easier logistically. You don't have to think
apply,
about it.
yeah.
Right. Our guests are Angela Thiel and Christine Eilers. You're listening to The Law Show here on AM 650. Our guests from Lindsay Kenney LLP. Christine, when people go to have one of these agreements drafted by a lawyer, is one lawyer okay? Or
No.
because there are 2 sets of interests, which may end up being conflicting interests, should both parties have legal representation?
It's essential for people to have independent legal advice.
Oh, I see. So
normally one lawyer would draft the agreement,
Right.
and then the other lawyer
the other
would just
party
look it over, give
oh,
them
okay.
advice.
And sometimes you negotiate them.
Yeah,
I've done one where 2 lawyers are in a room, 2 clients, and we're negotiating terms.
Almost like a mediation.
Yeah.
If you are already in an arrangement of married or cohabitation and have been for a while, does that eliminate you from doing an agreement? Are you past the point of no return? Should you have done one up front, and because you didn't, is it no longer available to you?
Strategically, you're much better off getting it before you get married or before you move in together, because otherwise there's not much incentive for the other person to sign it.
Right.
But at any time during a marriage or cohabitation, you can draft an agreement and sign it and agree to whatever you want.
I'm getting a lot, because I do a lot of estate planning work.
Right.
I'm getting a lot of cases where the parents are saying, or the executor of dead mom's estate is saying, these funds are not going to be paid to Johnny until Johnny has a prenup.
Oh,
Yeah.
Or Johnny
isn't
has
that
a cohab.
interesting? So moms and dads, even beyond the grave, are looking back and going, well, I'm not going to allow my descendants to make the same kind of mistakes I did.
Yeah.
In some cases.
Or in planning, if they're setting up a trust, a parent's setting up a trust or setting up some sort of other tool, then they make sure that their child, before they become a beneficiary of the trust or whatever, have a agreement in place. That's becoming really common because it's difficult to avoid those assets.
We need to take a break, but there's a lot of ads running, as there are typically at the end of the year and into the new year, and all this planning and stuff. And a lot of the ads for boomers here, and our audience on AM 650 is a boomer-dominant crowd. We are being encouraged to give our children ridiculous sums of money so they can go out and buy property and get in the game. I want to know how that works from a family law perspective. Our guests, Angela Thiel and Christine Eilers, are with Lindsay Kenney LLP. You're listening to The Law Show on AM 650, with more ahead.
This is AM 650's The Law Show. There's more of the show still ahead.